Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And today, oh, 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 we have a very interesting video about the Ripple v SEC lawsuit. And once more, guys, tomorrow is gonna be a ridiculously big day for the lawsuit. So make sure you are subscribed and make sure you have that notification bell on because you do not want to miss it. Once more, big stuff going down tomorrow. You don't want to miss it. Now, Jeremy Hogan just posted a video yesterday about Attorney Jeremy Hogan on the SEC v Ripple, SEC's big gambit, the hearing, the word, and the new timeframes. And it was interesting, all right? I watched it about 1.5 times right now just to make sure I have everything in the back of my head. And oh boy, is it interesting. Now, there's also been a couple of articles written about it, and I want to try and kind of compile his knowledge with my own to give you guys a good story for what's about to go down. And specifically, tomorrow is going to be such an important day. You guys all need to be really prepared because, as Jeremy also said, a lot of people are ill prepared for the amount of consequences tomorrow's decision could have. All right, so SEC v Ripple, why August 31st holds the key, the SEC's Queen's Gambit, and a damning email. The SEC played a high-stakes gambit in which it seems to be giving up its position on the fair notice defense in its hope that it will nail Ripple on XRP being sold as a security. So right now we're seeing a shift in perspective from, right, we want to strike down that fair notice defense to no, you just marketed or sold it as a security. Big difference because at first we didn't really understand exactly what the lawsuit was about. John Deaton pointed out, rightfully so, that the lawsuit was about every XRP crypto coin out there being a security, but right now that's not their thing, right? Right now there's not really their motive anymore. They're trying to go after how it was marketed. There's also a damning new email that has surfaced, written by an SEC staffer to an investor that could win the case for Ripple's fair notice defense, which we already have gone over, but still, let's dive into it. Ripple Labs Inc.'s legal battle with the US SEC seems to involve with every motion filed, with each faction developing a new attack or defense angle. Even as the battle seems to intensify, there are predictions that a settlement could happen in a few weeks' time. But according to one expert, everything relies on the August 31st hearing. And guys, this is not new stuff, all right? If you watch my channel all the time, you know we cover these things 9 out of 10 times before all the others do. This channel, I've told you all a couple of times before, I am usually so fast with the news, it takes others a couple of extra hours to catch up to this stuff. Not always, like an article like this has already been published for a couple of hours, but now I'm a little bit late to the party. But that's because this is not new info. This is a compilation of different pieces of info. It's a compilation of Jeremy Hogan's info. But once more, everything that he talks about, we've already talked about on this channel. There's no new crazy info like that. It's just conclusions, and sometimes conclusions like that may take some time or may take some preparation. So for all of you saying we're late to the party, no, we're not. We covered this before. But a conclusion before the concluding event is never too late. So what I do also want to mention quickly, however, is how this lawsuit is really dragging out my patience. I mean, I always thought I had some really nice patience. I always like to brag about that, but watching this lawsuit unfold, it feels like every day is the freaking same. Another motion, another development, another attack, another defense. And I know it's all integral. It's all a big part of something way bigger. I mean, it's really what this space is all about, but still, it's so time consuming. It's so mentally consuming as well. We just want a conclusion already, right? We just want this settlement already. But for months now, Ripple and the SEC have been squaring off in regards to the SEC's internal documents. These could prove whether the SEC considered XP a security in its inner circle or whether it's just decided to sue Ripple out of the blue. While the judge did rule in favor of Ripple, the SEC has fought against having to surrender its documents. It cited the deliberative process privilege, which protects internal government processes from normal disclosure in civil litigations. Ripple is aware that laying its hands on these documents could make or break its case. And now, come August 31st, once more tomorrow, we're going to do this live, We're going to talk about the entire live hearing. You guys can get to hear it that way. The court will hold a hearing on this privilege dispute in what could drag the SEC's view on Ether to the center of the lawsuit. In his latest video, attorney Jeremy Hogan observed, quote, "In other words, this upcoming hearing is very important because Ripple could potentially get some documents that could really help it advance its position that XRP is like Ether, and in 2018, the SEC said Ether is not a security, and therefore XRP is not a security." Two things to say about that one. One, Jeremy Hogan also points out that the SEC right now is really trying to hide it, but Ripple has also hammered on that. Jeremy Hogan found it fascinating, and the judge found it fascinating, that XRP and Ethereum look alike. Ethereum definitely at one point or another was a security. And so a key question about this all, which the judge knows, which Jeremy knows, which the SEC knows, which Ripple knows, is when exactly did that perception change? And who exactly gave the newest perception of it not being a security to the market? Once more, which all has to do with when did the thought process change? And was it incentivized to make it change? That's all questions right now. And what exactly does Ethereum differ from XRP? This will be the focus of the next 2 months of discussion. Ooh, I hope the microphone doesn't disconnect. I almost disconnected it again. Ooh. Okay, so this will be the focus of the next 2 months of discovery, which is the expert discovery phase. And in this phase, people who are vastly knowledgeable about securities and crypto will give their views to the court, which is the difference between fact discovery, which ends tomorrow, and expert discovery, which ends the 12th or 13th or something like that of November. Now, the SEC's Queen Gambit that backfired. From the very beginning, Ripple has been arguing that the SEC didn't give it fair notice and that it was violating security laws. For some time, the SEC focused on discrediting these defenses. However, at some stage, it decided to engage in a gambit, sacrifice its strong position on this defense in the hopes that it can pin down Ripple elsewhere. Hogan states, quote, "The SEC has deployed a Queen's Gambit in this litigation, sacrificing its position on the fair notice defense in order to solidify its central position that XRP was sold as a security," end quote. So a change of perspective. They've given up on their initial attack. And make sure you understand, guys, a fair notice defense can, theoretically speaking, win you the entire lawsuit. By the way, I'm amazed with how much we've involved with this lawsuit as well. I've never followed a lawsuit this much, and I've learned so much about the law, which I also find interesting. But I know now that a fair notice defense can be a critical part of a defense, because if you weren't warned and the people, and you are kind of the people, never could have actually known that you're doing something wrong, then you could still be in the wrong for doing it, but it's not as big a deal, so to speak, because if they are all of a sudden suing you without telling you to change, that's strange, right? I mean, depending on what you do, but if it's not fraud to the heaviest degree and you didn't know because there weren't any rules on it, how could you have known then? And the SEC tried to hammer saying, no, I mean, we did give proper rules, we made it clear. You can see examples of Ethereum and whatnot and yada, yada, yada. Yet, it wasn't really that clear. And that's what right now they're noticing. And like, Ripple's found out too much. The expert community has been doing too much digging. They have too much stuff. No. We said too many contradictory things. No. And they're backfiring. Or it's backfiring to them. Now, it all started when Ripple began attacking the SEC's stand on Ether. The regulator tried to play it this way, but the judge took Ripple's side. The SEC then claimed that William Hinman, its former director, was giving his own personal views when he claimed Ether wasn't a security, but that also is really not that true, though. Why? You'll see in just a second. And thus the gambit was set in motion, and this was it. The SEC was going to admit, to some extent, that there was confusion in the marketplace about digital securities in exchange for strengthening its position that XRP was a security. The SEC was caught in a tricky situation, though. Should it admit that Hinman's views were its official position, it risked Ripple proving that XRP was just like Ether and thus not a security. On the other hand, should it deny Hinman's sentiments and as its official stand, which it did, it risks Ripple claiming that there was no regulatory clarity at the time. And once more, guys, what we're seeing right now is actually the most beautiful result of all. The SEC stated, right, scenario number 2, no, William Hinman was not clarity to the markets, which basically means Ripple could not have known. But then Ripple finds out that other SEC members do see that speech as guidance, which is the ultimate proof for the judge that there is absolutely no clarity in this market. It's absolutely bizarre that such assumptions are made by the SEC. All right, more bizarre things from the SEC, however. It doesn't end there. The SEC seems to dig its hole deeper, at least through some of its most high-ranking officials. One of them is Hester Pierce, one of its 5 commissioners. She has come to be known as Crypto Mom, thanks to her never-fading support for the crypto community in an agency that seems to love cracking down on crypto. So, following the Hinman 2018 speech, in which he cleared Ether from being a security, Crypto Mom took to Twitter to describe it as a positive step in the SEC's relation with innovation. When Howie met Gary, a positive step in the SEC's relationship with innovation. Interesting, right? 2018. And it continues with what's perhaps the most damning evidence yet of the confusion and lack of clarity in the market. In late 2020, October, an individual, Frank, wrote the SEC to inquire whether or not XP was a security, and the SEC wrote back, "Please be advised that the SEC has not issued a determination on whether the crypto XP is a security. Whether a cryptocurrency is a security will depend on the characteristics and use of the crypto, which again are relatable to Ethereum." Now, a couple of things to say right here. Very many things, actually. One, there's been different SEC members, at least 3 now. I think even 4. Because we have Gary Gensler, we have Hester Pierce, and we have 2 other executives over at the SEC, whom have looked at William Hinman's speech as advising the markets. That is actually a really, really big part on its own. However, that's not where it ends. Another big part of this is the fact that within the SEC right freaking now, as we speak, there is a discussion going on about whether or not SEC members were allowed to trade it. And that is multiple-sided. On one end, if they were allowed to trade it, how come, right? Because, I mean, the theoretical speaker should have never, since 2013, because that's what they're suing Ripple for, been allowed to trade it. However, if they were able to trade it at what point to another point, why is that the case, right? That's a really big argument they're going to have to explain. Then again, they should also explain, in my own opinion, if the status of Ethereum being able to be traded changed from 2018 William Hinman's speech on forward, or the status of XRP or any crypto for that matter, just after William Hinman gave his speech. I personally would like to really see that. And another point is, can somebody actually point out to me why exactly William Hinman gave the speech? If it was just to portray his own opinion, yet the price of Ether pumped just afterwards, people thought they were getting clarity, and some others have stated that this was to clarify it for the markets a little bit. Because here you can see, it's a positive step in the SEC's relationship with innovation. So it basically is to, right, show some innovation and to kind of help the markets out. Yet, why then, if it's just his own opinion? It's so strange. This was in October of 2020, just 2 months before the SEC chair Jay Clayton filed a security violation lawsuit against Ripple. And also still, I would like to see Jay Clayton being deposed and just questioned on why exactly did he file the lawsuit just before leaving? Because I've never seen or heard about this before where a executive sues a company and then leaves the next day. Like, how does that make sense? If you want to sue somebody, you'd stick with that for at least a little bit, right? You might not stick with it till the end, but you're going to stick with your gut a little bit of suing somebody and trying to get some result out of it. Why would you leave then? Was it because he had millions to wait on him? Was it because that was an agreement he made with his company? Were these guys biased or whatnot? There's right now an investigation going on within the SEC, guys. It's happening. And one question I saw a lot of people have was, well, but Dusty, what's going to happen to every crypto made on the XP ledger? Here specifically, Jeremy, I have a question, quick technical one for you. If XP gets deemed a security, or sorry guys, a currency, does that make tokens created on the XP ledger also currencies that can be transacted at a retail level? I'm not sure how the law works on this one, all right? I'm not sure how the law would work on any of this type of stuff. I would say, and that's like a 90% certainty here, that no, it does not work that way. Because the SEC has really not mentioned the XRP ledger that often. They don't care about that. It's about XRP as a token right now. How it's being sold specifically is what they're changing their strategy to. They're giving up hope for the first attack. They're going into plan B. And the XRP ledger is as an entity on its own, doesn't really matter to them. And so every token issued on there is a separate little issue, which is also, I guess, coherent with Ethereum, because even though Ethereum is not a security, that does not mean that every crypto based upon Ethereum, every new token made, is not a security. Because theoretically speaking, a company can come in and literally create the most centralized piece of garbage on Ethereum in terms of almost everything. And then following this really small rulebook, then it would be fine. No, it wouldn't, right? At least I don't think it would. So I still think it would have to be on a case-by-case basis. And so no, this is not the case. Then again, eventually some rulebooks will just fall out, so I'm not really too worried about all of that stuff. But guys, that was it for today's video. Hopefully you all enjoyed it. If you did, make sure you press the like button and subscribe, and I will definitely see you guys again in another crypto video later today.